very, very warm welcome to our first legal conference, which is on the rising bar of medical evidence. We're delighted to have such a wide range of professionals here with us today. We've got legal professionals, medical professionals, some people from the judiciary, from the legal aid agency, government contractors, academics, and of course a wide range of NGOs as well. This is 2015 is Freedom from Torture's 30th anniversary year. And over the past 30 years, we've supported more than 55,000 clients through our clinical services, which are the backbone of the work that we do, but also through our medical legal report service, which is one of the cornerstones of what we do. The survivors of torture that we see have faced appalling violence and intimidation. Most have been targeted because of their race, their religion, their gender, their sexuality, or their political stance. They reach our centres after having fled for their lives and having endured long and very hazardous journeys to seek sanctuary. There aren't any quick fixes for the long-lasting impact of torture. The complex problems that our clients face are way beyond the scope of just one professional. They need a coordinated team effort, which may take many months or even years. So our highly trained clinical staff is uniquely qualified to meet these needs. And through our holistic approach, we offer psychiatry, clinical psychology, psychotherapy, counselling, complementary therapies, support with housing and welfare, and medical legal reports. We are the only torture rehabilitation centre in the world that systematically uses evidence from our medical legal reports to produce reports that enables countries that are being torturing their citizens to be held account for that torture. We're very proud of the success of our latest two reports in particular. Rape as Torture in the DRC, Sexual Violence Beyond the Conflict Zone, was published in June 2014, and that resulted in the closure of detention centres and the release of detainees in the DRC. And more recently, Tainted Peace, the torture in Sri Lanka since May 2009, was published just in August this year. And yesterday, the Human Rights Council adopted a resolution on accountability in Sri Lanka that was based on a landmark war crimes investigation, relying heavily on our forensic evidence. Privately, investigators say that our evidence was central to the strength of the report. We're also the only organisation in the UK that facilitates a survivor-led network to communicate their learning about torture prevention and protection. And they communicate that directly to influencers and decision makers. So the topic of today's conference, Proving Torture, an ever-rising bar for medical evidence, was chosen because it's of particular importance for freedom from torture just now. Over the past 30 years, the level of medical evidence demanded of us has been constantly increasing, while pressure to reduce the amount of time taken to produce a report has also been increasing. So the result of the rising bar of evidence is that we're able to produce fewer reports each year. And as you'll hear shortly, we're seeing our medical evidence challenged more frequently, resulting in more appeals than should be necessary in the asylum applications. The impact of this is not just the financial impact on the Home Office, the judiciary, and for the taxpayer, as more decisions are appealed, but most importantly, we mustn't forget the absolutely devastating impact on survivors of torture that are at the heart of this process. It is disappointing that the Home Office felt unable to accept our invitation to attend today, citing work pressures connected with Syria, but we will make sure that learning from this conference is transmitted to them. And now, as Chief Executive, I can't let the opportunity of having such a large number of people together in a room go without talking a little bit about the future plans and our aspirations for freedom from torture. We currently receive in the region of 1,300 referrals a year. We currently turn away 2 clients who meet our remit and who meet our prioritisation criteria for every 1 client that we see. So our long-term vision is to increase by 150%, that's 2.5 times, the number of clients that we're able to support by 2025. And when we're doing that, that will mean that we'll only be turning away one client for every one that we see. So we see that very much as an interim goal. It's not our end aim. We support survivors in 5 centres in Glasgow, Newcastle, Manchester, Birmingham and London. We don't receive any government grants for our clinical work, and so we mainly rely on donations from individuals or trusts and grant-giving organisations in order to be able to support our survivors of torture. We currently need to generate almost £8 million a year in this way. And so to achieve our aspirations, we'll have to raise £20 million a year. And that's before we start to think about having to scale up to meet the expected demand from the extra 20,000 Syrian refugees that David Cameron has announced that the UK will be welcoming into the country. We think that we may need to double our capacity next year just to meet that demand. So we have now launched a special Syria appeal to help us to meet the challenge. We need an extra £2.6 million every year, so we have a huge mountain to climb. So please, can you help us by spreading the word around your networks and considering if there's any way that you can support us either as a company or as an individual?
I have the job of both chairing and also doing a bit of an introduction about the Istanbul Protocol. So I'm going to do that first. But precisely as Susan has introduced me, that's how I'm going to be introducing my colleagues. You have speaker biographies in front of you. When you're not tweeting, you could consult them. And they're really rather impressive, and it would be a shame for me to take too much time away from the day to read them all out. So with that, I'm just delighted to be home in Freedom from Torture and to be able to give one or two reminiscences about the Istanbul Protocol, the Istanbul Principles, the manual, the UN manual on the prevention and investigation of torture. The origins lie in a conference seminar organized by, I think it was the Human Rights Foundation, the Freedom from Torture equivalent in Turkey, which identified the problem of proving torture for various purposes. That led Physicians for Human Rights to take the lead in having an international consultation that would come up both with principles, legal type principles that would be relevant to assessing the effectiveness of any kind of ordinary investigation of torture, and also medical documentation of torture more specifically, with all the appropriate protocols and forensic background necessary. I know that Freedom from Torture, or the Medical Foundation for the Care of Victims of Torture as it was then, and I still prefer it, was very much involved in the process. In those days, Dr. Michael Peel was working in the organization, and he represented the organization at various stages in the consultation process, including the final conference in Istanbul, which adopted the principles. I was there too, at that time, indeed, in my capacity as UN Special Rapporteur on torture. And it was in that capacity that I was able to draw the principles to the attention of the UN General Assembly and get the General Assembly to annex them to a resolution and consider them a useful tool in the investigation of torture. The UN Commission on Human Rights, the predecessor of the Human Rights Council, then also followed suit. The purpose won't come as much of a surprise to you. Torture happens in the dark and secret reaches of state power, and states are very good at denying their responsibility for it, regardless of how plausible or implausible those denials are. Nothing like a bit of science to undermine those denials, and obviously medical science can be very helpful, and not just in the way of identifying possible causes of physical sequelae, but also mental as well. And indeed, as most of you will know, for international legal purposes, torture doesn't even have to be physical. The infliction of severe mental pain or suffering for the same sorts of purposes as physical pain and suffering are normally inflicted can also be considered to be torture. And so doctors, I have discovered, I have seen very experienced doctors from Physicians for Human Rights at work, specifically during an inquiry I was part of, set up by the King of Bahrain, which allowed me, as a commissioner on that commission of inquiry, to sit in on some interviews that these doctors, which the commission had asked to help us, were conducting with alleged victims of torture. And the process of inquiry was absolutely one that, first of all, would do credit to any really good cross-examining QC, but also would go further than that because of the deep understanding of some of the psychological dimensions of torture. And one of the things that I realized during one interview, for example, that the doctors can do and a lawyer wouldn't necessarily be able to do is get at what really hurts, which can also be therapeutic as well. So that, for example, a doctor who had been tortured was being interviewed by one of our doctors, and he described the torture in very professional, deadpan terms, the physical torture. And then he also described the insults to him as a doctor for having helped others, thrown at him by his interrogators. What kind of doctor are you? And at that point he blubbed. He actually started crying. What had really hurt him was the insult. That was the longer term damage, the insult rather than the as much as the physical pain and suffering. Just to make the point about mental pain or suffering, and just to make the point also about the ability of skilled forensic doctors to get at these issues. Why is this important? Well, it's important for all the reasons why we want to document torture. In a perfect world, for the prosecution of alleged torturers, for exposing patterns of violation, for providing remedies for victims and survivors of torture, for avoiding refoulements, people being sent back to countries where they've already faced torture, and indeed, as some in this room are familiar with, trying to persuade courts that countries that governments may want to send people back to are not as safe as they want to believe. And what it all boils down to is ultimately a question of the burden of proof. All the international bodies dealing with torture would put the burden of proving that torture did not happen certainly on the government of the country where it took place, but also would not put an intolerable burden on the individual alleging torture in other fora as well. That once a reasonable case has been demonstrated, it's then up to the respondent to rebut it. So I must say I've been a bit shocked myself to find that somehow our government is able to declare quite freely and simply that, no, this country is fine, we know it's fine, we've seen it's fine. And that seems to be much better proof than freedom from torture's studies based on serious analysis, but because confidentiality is a necessity, the individual cases can't be subject to cross-examination. Really a very depressing situation. So that's why the Istanbul Protocol is important, why more needs to be made of it. There may also be problems of over-reliance on it, and perhaps during the discussion I'll come back to that. There's a risk of deconstructing it to destruction as well. But we'll come back to that. I've said more than enough right now. And so I now turn to my colleagues on the panel that I'm very proud to be with. The first speaker is going to be Helen Brady, the Senior Appeals Counsel and Head of the Appeals Section at the Office of the Prosecutor at the International Criminal Court, with extensive experience of international criminal work at the ICTY, the ICTR, and the Lebanon Tribunal. Just a remarkably authoritative background to make an international criminal law presentation to us. Helen.
Thank you. Thank you very much for that kind introduction. And good morning to everybody here. I'll just get myself set up. And I know we only have 10 minutes apiece, so I'll try and say what I need to say in that time, and of course we'll have time for questions afterwards. What I'd like to look at is how we prove the crime of torture in the international criminal courts and tribunals. And I'll look a bit at the ICC, where I'm presently working, but also at the other courts, the International Criminal Tribunal for the former Yugoslavia, where I did once work, and the other courts, Rwanda Tribunal, Sierra Leone Court, and the extraordinary chambers in the courts of Cambodia. So that'll be the predominant focus. And then I'll turn just very briefly at the end to look at a slightly interesting question on the inadmissibility of evidence obtained by torture in these courts and how they deal with that issue. Now, when I was putting this together and thinking about how the work that I do and my colleagues do in the international criminal courts and tribunals, it differs, I think, quite a bit. There are obviously similarities, but there are some pretty major differences in the method and approach to proving torture as a crime in international criminal courts and tribunals than perhaps when establishing torture as a violation of human rights in order to obtain a judgment to that effect in a domestic or a regional court, or when seeking the exclusion of evidence obtained under torture in a national trial or an extradition proceeding. And there are several distinctions, but some of the main ones I have on the slide. When we're dealing with torture as, say, a crime against humanity or a war crime, most often where the likelihood is that the person who's on trial, the accused, is not the direct physical perpetrator of torture and the other crimes. Usually we're dealing with higher up, people who are more removed from the, geographically, physically removed temporarily from the torture that may have occurred, we say, on the ground. There's also the great likelihood that torture occurred in our crimes on a very large scale, hundreds, thousands of victims. And by nature of the crimes that we pursue, crimes against humanity and war crimes, especially when committed on a large scale, that the crime will form part of a course of conduct involving multiple other serious crimes in addition to torture. Another very important distinction is that the victims and also the direct physical perpetrators even, in many of the incidents which will form, say, part of the case, may not even be identified. Another key distinction is that the investigation and the prosecution can occur many years from the actual event of the torture, and more often relies on witness recollection going back to what had happened, and documentary evidence, for example. We also have jurisdictional factors which affect which crimes we can select, etc., or which crimes from situations we can select. This is a gravity requirement for crimes, which again will very often minimize any case where it's a borderline as to whether or not the conduct does amount to the seriousness that is required for the crime. And then just finally, the key issue, as I mentioned before, is in international criminal law, what we're usually looking, the main thing we're always looking at is the linkage, whether that crime can be linked to the person who we've charged or wish to charge or who's on trial, and not necessarily the crime base, which means like what happened actually on the ground. So for that reason, very often the nature of the conduct which is inflicted upon the victims may not, interestingly enough, be as vigorously disputed that it actually occurred. It's more, well, it may have occurred, but I'm not responsible for it. That's more the defense. But the result of all these factors is that the practice at the International Criminal Court, courts in general, tends to favor evidence which goes directly to the conduct and the mental state of the actor rather than the effects on the victims. That's where the concentration of the evidence is. Although having said that, obviously evidence about the effects on a victim is highly relevant and probative, especially when it comes to sentencing or when proving the severity requirement for which distinguishes torture as a war crime, say, from outrages against personal dignity as a war crime. So tools such as the Istanbul Protocol can and do assist investigators and prosecutors to accurately calibrate the degree of pain and suffering which may have occurred or resulted from such unlawful conduct. And I'm not an investigator at the court, but I've dealt obviously with a lot of them and spoken to them about their use of the Istanbul Protocol. And what they've said is that they use the principles, essentially. I mean, most of them are very, very common sense when interviewing, etc. And so when they're interviewing witnesses, they do use those principles, but it's more in the context. At the moment, our investigators are working on training as many investigators as we can in the peace model for investigative interviews with vulnerable witnesses, and that peace model is particularly designed for vulnerable witnesses, including victims of torture, and methods of how best to elicit and conduct the interviews. Now, just very briefly, as a primer on torture as a crime against humanity, we have, in international criminal law, there are basically three main ways or three distinct crimes which cover torture. There's torture as a crime against humanity, torture as a war crime, and torture as genocide. The elements of the crime of torture as a crime against humanity, they're quite similar between crimes against humanity, torture as a crime against humanity, and torture as a war crime. There are some distinctions, but essentially it's a crime against humanity, so therefore the conduct's always got to occur within the context of a widespread or systematic attack directed against a civilian population. The prosecution has to prove that the perpetrator intentionally inflicted physical or mental pain or suffering upon one or more persons. Those persons were in the custody or under control of the perpetrator. It did not arise from lawful sanctions, and there's a knowledge requirement that the perpetrator knew that his or her conduct formed part of the widespread or systematic attack. Interestingly, for this crime, it need not be established. For the ICC, this was quite novel. Instead of having the prohibited purpose, the classic prohibited purpose, which is to obtain information for punishment, intimidation, for discrimination, etc. For crimes against humanity, this element is different. You don't have to prove a prohibited purpose for torture, but you just prove that the persons who were tortured were in the custody or control of the perpetrator. And you can also see that for this definition, both crimes against humanity and war crimes, there's no state actor requirement in international criminal law, and that was something established in one of the early ICTY cases. Again, torture is a war crime, very similar, but of course now you're talking about, you have to prove as the prosecution the nexus with the armed conflict that's going on, either international or non-international armed conflict. Similar elements, intentionally inflicted severe mental or physical harm. The person has to be a protected person, one of the categories under the Geneva Conventions, or civilian, hors de combat, etc. People who are taking no active role in the hostilities. Here for war crimes, that's the distinction. We have to prove that the torture, the intentional infliction of the harm was for one of these prohibited purpose, obtaining information, a confession, a punishment, intimidation, or discrimination of any kind, and then the nexus requirements that it's got to be associated with an armed conflict, and the perpetrator has got to know that his or her conduct was occurring in that context. Now, if we can't prove, where the prosecution can't prove one of these, say, the prohibited purpose element, we can still charge. We have other crimes that we can charge if we prove the ill treatment as the same degree of severity as torture could meet other war crimes, for example, inhuman treatment in international armed conflict or cruel treatment in the non-international armed conflict setting. And if we cannot prove the severity of the ill treatment, the extreme, the severe physical or mental pain or suffering, we may still be able to prove the war crime of willfully cause great suffering or outrages upon personal dignity. There's also types of genocide can be committed through torture as well. Very quickly, because I see I only have 1 minute left, which is a bit disturbing. Torture cases presently at the ICC, we only have a few. It's charged at the moment in the Ongwen case, Lord's Resistance Army commander, Dominic Ongwen, and also we have 4 arrest warrants in suspects in the Darfur cases whose charges also include torture. There are also several cases in the ICTY, I won't go through them, but there are illustrative categories of conduct recognised in both Frunzia and Delilich on this. But what's really interesting, if you look at these cases, whether you're talking about the ICC or ICTY, it's very much that the courts are drawing the conclusion about torture in a sort of, it's a conduct, a focus on the conduct. So rather than seeking, there can be direct evidence from the witness or opinion evidence from the expert, but rather than looking at the effects on the victim, these matters are usually looked at as a matter of inference by the trier of fact. So once we prove the conduct of that type occurred, then the effects on the victim can be sort of inferred. And some types of conduct, in particular rape, have been held to be per se accepted as serious enough to amount to torture. I won't have time because I think my time is pretty much up. But there are some interesting angles about the inadmissibility of evidence obtained under torture in the international criminal courts. Basically, such evidence is not admissible. We have a variety of statute provisions and rules about this, but the basic rule is that evidence which is obtained under oppressive conduct or torture would not be admissible, although there are very few examples, funnily enough, of this in the international criminal courts. And one final point, one very interesting case at the extraordinary chambers in Cambodia is where the investigating judges tried to rely on evidence. They wanted to get in the confessions which were obtained from victims in the Tuol Sleng torture prison. The prosecution and the investigating judges wanted to rely on aspects in those statements, under those confessions obtained under torture, as proof of their case, not the substance of the matter against the particular person who was being tortured, but to prove certain features of the regime of the Khmer Rouge. So, for example, biographical data, who was doing what job and what was going on actually in the Tuol Sleng facility. Although the investigating judges very much wanted that evidence to go in, ultimately the trial chamber said no and took a very strict exclusionary approach following the Article 15 of CAT, that no statement can go in except to prove that the torture occurred, of course, but not as proof for the truth of the matter that the person is saying. So with that, I will end, and of course I'm happy to answer any questions you might have at the end of this. Thank you very much.
The next colleague on my left, Pierre Duterte, who we first met when he was working with Havre, the then only French equivalent of freedom from torture. Now he has founded his own organization, the Parcours d'Exil, which is a healthcare center for victims of torture. Extremely experienced again, as usual. I won't go through the bio, it's right there. Pierre, over to you.
Thank you very much. I hope you will manage with my French fried English. I will do my best. Usually I don't like to read, but in English I think I've got to read. I will try to be quick so I don't get tortured or humiliated by this 1 minute post. I want to go back safe to Paris tonight. Let's say, for me, the real application of Istanbul Protocol, which I know since its creation, considering my old age, well, Sir Nigel Rodley don't change physically. I do. It started only a few years ago when I went to realize forensic examination in Phnom Penh for the Khmer Rouge trial, or in Peru for the Fujimori era, well, you know, of the trials in Lima. And 2 years ago, I made expertise in Brussels for 3 Muslim prisoners in Belgium who complained about being tortured in Brussels prison. So they asked me to go and I make expertise for these people. Quite different, but still on the Istanbul Protocol. Recently, I went for 1 month of training session in Rwanda, in Burundi, and Democratic Republic of Congo with the IRCT and under, I'm sorry, I cannot pronounce his name. I've been living with him for 1 month in this region, which is under Oskaspispili. I don't know, it's Turkish, you know. And he was one of the writers of the Istanbul Protocol, and we worked together. Can you say it?
Under will do fine.
Yeah, Under, it's easier, but it's a second name only. It's not fair for him, but well, I can do it. And it was quite interesting for us because we have been training people in these 3 countries. We have been training psychologists, medical doctors, and etc. But we had the chance to be able to train policemen, lawyers, and even military soldiers who came to the training. There were not a lot, but they were present. And it was quite a difference for me because 3 years ago I've been working in Rwanda and we were not supposed to talk about torture. It was forbidden. The only word of torture would have taken me to prison. But now this time it was possible. And it was really very interesting for me to be able to exchange with policemen. And so they agree there was torture in their country, but only a few times with mad policemen. But anyway, they heard us, and that was interesting. Why did I use so late, after more than 20 years of practice, taking a victim of torture, Istanbul Protocol? It's because in France, it's not used in France for the asylum procedure. It's due to the fact that some years I had to write about 400 medical legal report for the court in France. And you can imagine it's not easy for me to write 400 times 20 pages or 30 pages certificates on top of my job. And anyway, they don't take care much of it. The Istanbul Protocol is not used at all in France in the asylum procedure because the judges or the administration don't ask us to do it. So I am, as a doctor and as a psychologist, I am only providing certificates when the patients are asking me. And of course, it's not the same. I would rather say it's quite difficult to make precise certificate when it's not a requirement. It's difficult to cope the therapist place and the expert place. I will try to explain that better after. Well, and especially in France, the main problem is that I don't know how it works in other countries, but in France the main problem is asylum seekers, torture victims, are asking a lot of certificates everywhere. France is a country where you have to prove everything, and let's say you're not trusted anyway. So people are asking certificates all around the place. They go to court with 20, 30, 40 certificates sometimes, and it's really most of these certificates are not satisfying, and it brought to a depreciation from such document. The authorities don't ask, never ask. I've never been asked by an authority in France to make a medical report. I'm just making them when the lawyers of the asylum seeker ask it. I've seen some certificates from doctors which were completely inappropriate and useless, and because of the way they were written, become even counterproductive for the patients. They had a feeling of frauds, lies, in a climate which is, for refugees, unfortunately too usual in the French administration. What to say in front of medical legal certificates which contains sentences like, I certified, I, Dr. something, certify that Mr. X or Mrs. Y has been tortured. I've seen that many times. Well, you can understand it's quite strange because it just, for me, it makes sense that the doctor was in the torture place. I'm convinced that in France, the often poor quality of the forensic certificates, not to say worse, contribute to the depreciation and the refusal to take into consideration what could be really a very important part of a case. Well-drafted certificate which respects the rules of the Istanbul Protocol, is not really contestable by a court. It's not an easy language in English, you know. French is really much more easier. Well, you should try. Well, not joking, it's nice language, you know. Personally, as I cannot use the Istanbul Protocol directly every time, I always try to refer to it to make my certificates as good as possible. For me, one of the main contributions of the Istanbul Protocol is, but that's only my opinion, that it raises also the negativity of certain examination. For example, it's mandatory to write the examination of the eardrum reveals no lesions or no scar or nothing. For me, it's very, very important that because it shows to the judge, to the court, that everything has been checked. If you don't talk about it, I can always say, did you check that? Or why didn't you check that? If you just say, there's nothing in this place, it means you have made a head to toe, yeah, that's the way to say it, the head to toe examination. She's not putting it yet. A maximum of information is given, and thus the credibility of the information is increased. It becomes very difficult to dispute the reality of the results because of the quality of the examination. That's very important. The better is the certificate, the most difficult is it's possible to destroy it, let's say. Well, let's say about two little problems I have personally with the Istanbul Protocol. The first one is, for me, it's a restrictive definition of torture, which leads me to about 20 years to have fight with lawyers and everyone. But I think for me, the medical definition I have of torture is quite different from the legal one. The second difficulty I had with the Istanbul Protocol, but it's really a personal one. It's got nothing to do with the Istanbul Protocol. It's I am so accustomed to my therapist position, I couldn't find enough to limit myself to an expert position. But that's the way it is. It's not simple because whether in Peru or in Cambodia, I was confronted with victims from whom I was about 40 years after the facts in Cambodia and about 20 years after the facts in Peru. I was the first person to listen to them and to be interested in what happened to them, and with questions who seems to try to understand them. A victim I evaluated in Phnom Penh, which I met by chance 3 days later in the street, took me in his arms and explained me that since the expertise, he felt much better. So it's a particularly positive point of the Istanbul Protocol to realize, as quite often in our job, it could be an unintentionally therapeutic tool. I think the Istanbul Protocol needs an upgrade to a version 2.0 because there is a lot of new medical X-ray, RMI, and stuff that should be included. Yeah, okay. I'm just saying for an end, so I will be just in time. For an end, let me say that I'm convinced that the fight against torture, the fight against the immunity of torturers, passes by indisputable forensic certificates. You have strange words in English. You know? Forensic certificates, and so impossible or difficultly possible to reject. The Istanbul Protocol, for me, is a tool, probably one of the best, when properly used to fight against impunity. Thank you. I made it.
We now are going to move on to our next speaker, Stephanie Harrison, QC, on my right. She's a very experienced immigration lawyer in immigration and asylum claims. She is also a member now of the Equality and Human Rights Commission since this year. And she won, I have to say, the Liberty and Human Rights Lawyer of the Year award in 2013 for her work as an advocate and commitment to progressing the rights of immigrants and asylum seekers. Forgive me for being a little bit lengthier there, but the NGO world has to stick together. So, Stephanie, over to you.
Okay. If it's okay with everyone, I'm going to sit down rather than walk over there. Given the constraints on time, we don't want to waste any time. Practicing in the field of asylum, it must, of course, always be stated from the outset that we're not concerned with proof. We're not concerned with establishing, as we ordinarily are in civil litigation, proof that things occurred in the past or will occur in the future. The fundamental truth about determining asylum claims is that you are making an evaluation. You're not proving anything. You're the extent to which you have a burden. It is about whether there's a real possibility that events occurred in the past, as well as whether there's a risk that they will be repeated or will occur in the future. That's obviously well known to every single person who sits in this room, but it needs to be constantly restated because, as Sir Nigel said, whatever the tools, whatever the policy, whatever the principles of the legal framework in which we operate, it's how it is applied in practice. And critical to the evaluation of claims of past torture is recognition and a proper, careful application of that fundamental aspect that we are not proving anything. We're making assessments about whether something occurred is a real possibility. And it's in that context that one does have to start from the premise that including the consequences of the use of the Istanbul Protocol that we have seen over time, and increasingly so, imposition of impermissible, in my respectful view, and impossible burdens being placed on applicants to prove past torture and on the medical experts who we call upon to make assessments. And that burden and those increasing demands on what's necessary to establish a real possibility that the individual was tortured in the past is having a fundamental corrosive effect on the ability of the asylum system, at least in the United Kingdom, to ensure effective protection and effective and proper investigation. And it would certainly be my experience after 25 years that despite our greater knowledge, understanding, despite excellent tools like the Istanbul Protocol, we are at a place where the risks of wrong decisions and individuals being refooled and returned to places of torture and ill treatment at risk of future persecution is greater now than it ever has been in the past. And I think we have to start from that proposition when we come as lawyers and practitioners to understand where we are and what is necessary to improve the protection system in place for those who come to our shores seeking asylum. Now, what I've done in a paper that's in the pack is to review the case law going back over the last 20 years, I suppose 15, 20 years. And I've done it sequentially so you can see where we are. One of the things that one can say about the case law in the United Kingdom is that rather than there being too little case law, there's an overwhelming amount of jurisprudence, much of it contradictory, nothing that is consistent, many cases over time constantly repeating the same errors of approach in evaluation of asylum claims and in particular assessment of torture. So our jurisprudence does not help us. There are some simple propositions that have been constantly contested, but ultimately you can see if you read my paper, those themes come through. And those themes are that clearly assessment of credibility, personal credibility, is not an end in itself. If you have a medical report, you cannot reject the person's credibility because of inconsistencies or other implausibilities about their account and then use that to reject the medical evidence. It has to be a holistic approach, and you have to make an assessment of the plausibility of the individual's account or its credibility, taking into account that medical evidence, not least because if you accept the medical evidence that the person is a victim of past torture, that's inevitably going to impact on any their ability to give coherent and consistent accounts of traumatic events over time. That principle, established in the Court of Appeal in 2006 in a case called Mabenga, is constantly in issue and is not universally and properly applied, so that on a regular basis over the years I've had to draft grounds of appeal precisely on that ground. But it's obviously critically important in an asylum determination process that does turn very much and heavily relies upon assessments of personal credibility. The second principle, medical assessments are not simply uncritical reliance on the word of the individual. They are the application of skilled expertise and assessment, with medical experts applying their own critical evaluation to the plausibility, not necessarily the credibility, but the plausibility of the count in light of the medical sequelae that the doctor is able to identify, whether that's physical injuries or psychological sequelae of ill treatment. Again, the Court of Appeal have had to state that on a number of occasions. It's continually contested that medical experts only uncritically rely upon the word of the individual, but the case law, I would say, is clear on that and needs to be consistently applied. Finally, that medical reports are capable of corroborating an account of ill treatment. And again, one might not have thought that needed to be contested, but if you look at the case law that we've set out, that's been a hard-fought battle in the courts to establish that a medical report does provide supporting evidence of the testimony of the individual. And again, that is a matter continually contested, routinely contested by the Secretary of State, however compelling the medical evidence and however compelling and however much the medical practitioner has complied with the Istanbul Protocol. And so those, I would submit, are the key principles. They are contested, and it's in that context that the Istanbul Protocol has really been of most help to asylum lawyers and has led the courts to endorse those critical, simple propositions that have been so long fought, particularly in two cases, a case called SA Somalia in 2006. The Istanbul Protocol was relied upon by the Court of Appeal to reject to conclude that the immigration judge had erred in law by rejecting medical evidence because they'd rejected the credibility of the individual's account, and more recently followed in a case called Jail by the tribunal. So certainly the Istanbul Protocol has been a critical tool in establishing the relevance and the probative nature of medical evidence. What we can, however, say, if we now look at the subsequent, more recent case law, is that it is now, however, being used as a means for rejecting claims for ill treatment, because the compliance with the Istanbul Protocol is being seen as a necessary requirement for any medical report. And if it doesn't strictly comply with the approach and the guidelines in that instrument, it can be rejected. And unfortunately, we do not operate in a system where there is available to all those who make a claim of past ill treatment a medical practitioner who can and understands and can comply with the Istanbul Protocol, nor lawyers who understand its significance and how to instruct experts to carry out those kinds of reports, because we do clearly operate in circumstances where the funding regime for representation of asylum seekers is really threadbare at the moment, and there is increasing numbers of incompetent practitioners who are taking up the gap that there is in terms of representation. So there are very many individuals who have medical reports that would or do give some support for the account, but they are being rejected because they do not comply with the Istanbul Protocol. The other aspect of concern is that because the Istanbul Protocol requires within it the expert to address whether there may be alternative explanations, whether that's through work or through other kinds of injury, even self-infliction, the failure of experts to address alternative explanations, even in cases where they're of the view that the injuries that the individual have are consistent or highly consistent with the account that they've given, they must still go on to say why other explanations, of which there is no evidence, either presenting evidence from the individual's account or, and obviously critically, there's no evidence from the Secretary of State, even if they're disputing the account, they must still nevertheless prove the negatives and with cogent reasons and based on expertise, reject alternative explanations. So you do have cases that say, well, if the expert is going to say, I don't think this was caused by sports injury, for example, if your person happens to be to have been involved in some sport, they have to have expertise in sports injuries. Or if they're going to say it wasn't caused on battlefield, you have to have expertise in battlefield injuries. Now, there are some exceptional doctors who may be able to disregard every kind of conceivable injury that's possible, but I haven't seen them, and you can see how the criteria in the Istanbul Protocol is being presented as a hoop that you have to cross, both for the medical practitioner and often are not able to, as well as for the individual applicant. All of you, no doubt, will be aware that this approach has been applied to the context of allegations of fabricated claims of torture, where it's said that third parties have deliberately inflicted torture, and that's the explanation for why the person has the injury on their back. That the most recent case is KV, which is going to the Court of Appeal, so we'll have to see what happens there. But one can see in that case just how far this approach to the Istanbul Protocol can undermine safe and fair determination of asylum claims, because that was an individual who had injuries highly consistent with his account of torture in Sri Lanka. It was a form of torture, burning with hot rods, that is known to be practiced in Sri Lanka, but nevertheless his case was rejected on the basis that the court could not exclude, nor could the experts, because surprisingly experts don't have experience in self-infliction injuries because there is no evidence that it occurs, and that left the tribunal considering itself to be free to apply its own knowledge and therefore reject the account of the individual. Now, obviously, As I understand it, that case is not being routinely applied across the board, which is because of its obvious difficulties in its application. But nevertheless, it is a decision of the upper tribunal that is being appealed. And so if it were to be endorsed, one can see how serious that decision and that approach could be to the proper evaluation of claims for ill treatment. So when it came to my conclusions, which in reviewing the case law, one of the points that which is in page 17 of the paper, one of the points that one has to make from the outset is, as I've said, however good the legal framework is, however consistent the policy is with international norms and practices, the important factor in asylum determination, perhaps above all others, is the political context in which we operate, because there is no other area of law that is so politicised than asylum determination. And it is the culture of disbelief, of challenge, of refusal and rejection that operates and is ingrained within the Home Office that means that we do constantly have to argue over cases where on any fair application of the standard of proof and the correct evaluation of asylum claims, these individuals are entitled to protection, but nevertheless their cases go through the system and they are vulnerable to being rejected because of the restrictions and constraints that are placed on the kinds of material that is going to be accepted as demonstrating their past claims as well as their future risk. The Istanbul Protocol has been a key instrument in underscoring the importance and the independence and the corroborating nature of medical evidence, but we have to guard against, and we have to hope that the courts, and the Court of Appeal, certainly the higher courts, will guard against it becoming a means by which medical evidence is again subject to restrictions and limitations that fundamentally undermine its significance and importance in asylum determination. Ultimately, one has to recognise that in this scenario, the Home Office is essentially sitting on its hands, able to say, we dispute this evidence, but without ever having to come to court with their own contrary medical evidence. And that, I would respectfully suggest, is wrong. It's wrong in a process which is not supposed to be adversarial but inquisitorial, in a process, and particularly in appeals, that are supposed to be non-technical, where you don't need a lawyer and where increasingly you do not have a lawyer. That cannot be right. And if it is an adversarial process, then it's fundamentally unfair that the Secretary of State can assert that your claim is wrong, that your medical evidence doesn't establish anything, and that you may even have fabricated your claim of torture without themselves bearing any evidential burden at all. We are really at a juncture in terms of effective protection, and I would be interested to see how individuals from practice can show that the Istanbul Protocol is the proper and protective tool that is intended to be, rather than one that is now being used to undermine claims for asylum. I think I probably went long.
Good morning, everyone. It is my great pleasure to make a modest contribution to this auspicious event and to form part of this distinguished gathering. I have some reflections on the subject of torture, which I confess were prompted by a piece written by a PhD candidate upon which I stumbled some weeks ago. The student wrote the following. In 1971, the Hillside Singers, in a song designed to inspire worldwide unity, sang of how they'd like to teach the world to sing in perfect harmony. If anyone remembers the song, you'll be betraying your age, but feel free to sing it during the interval. Apparently, the inspiration for the song came from the writer's experiences while delayed at Ireland's Shannon Airport. In the same year, 1971, something else was brewing in the island of Ireland, to which I will come in just a moment. A 1977 memo to the then Prime Minister James Callaghan from his Home Secretary Merlin Rees regarding court proceedings, to which I will turn presently, is couched in the following terms. It is my view, confirmed by Brian Faulkner before his death, the Prime Minister of Northern Ireland, that the decision to use methods of torture in Northern Ireland in 1971 and 1972 was taken by ministers, in particular Lord Carrington, then Secretary of State for Defence. The student continues, and just like the song, the British government wanted to teach the rest of the world, exporting its torture techniques worldwide. There was also perfect harmony, albeit within two distinct groups, the torturers and the tortured. The Brazilian Truth Commission, in those days of the dictatorship, heard Colonel Paulo Malhes, a torturer under the military dictatorship, express his admiration for the British military dictatorship and for the British system of torture. Meanwhile, General Ivan de Sousa Mendes, the head of the dictatorship's intelligence service, told how Britain ran courses for the dictatorship. By 1976, the adoption of what became known as the English system was regarded as facilitating a move from more physical forms of torture towards more acceptable standards of interrogation, such as those permitted in my country, which would be less likely to draw international condemnation. Article 3 of the Human Rights Convention was probably something of a slumbering giant in the United Kingdom before suddenly exploding into life in the interstate proceedings brought by the Republic of Ireland government against the UK government in 1971, the first such case of its kind under the Human Rights Convention. On the 18th of January 1978, the European Court of Human Rights gave judgment in what is reported as the Republic of Ireland v. the United Kingdom. The impetus for these proceedings was the introduction by the British government in Northern Ireland of special powers of arrest and detention without trial in 1971 in response to what is euphemistically known as the Troubles, coupled with a series of interrogation practices. These entailed in particular the use of the so-called 5 techniques. Wall standing, that entailed a forced spread-eagled position facing against a wall for many hours on one's toes. Hooding, you can guess what that one entailed. White noise, sleep deprivation and deprivation of food and drink. The UK government had astutely enough previously served the requisite notices of derogation under Article 15.1 of the Human Rights Convention, invoking, in the words of the Convention, a public emergency threatening the life of the nation. In those days, the two-tiered structure of the human rights machinery in Strasbourg was in vogue, with the result that the European Commission investigated and decided the case first. Their investigation lasted fully 5 years. They held unanimously that the 5 techniques constituted torture and that some other practices amounted to inhuman and degrading treatment. The case was then referred to the plenary court. By this stage, the position of the British government was that the deployment of these techniques had been discontinued, and indeed the government was conceding the Commission's finding of torture. Remarkably, it now seems in retrospect, the court insisted upon reopening the finding of torture and reversing what the Commission decided in the face of the government's concession. The court's pronouncements on the issue of burden of proof are especially noteworthy. First, it rejected the suggestion that one or other of the 2 states' parties bore any burden of proof. Second, the standard of proof applied by the Commission, that of proof beyond reasonable doubt, was endorsed by the plenary court. The court made 2 further major pronouncements concerning Article 3. First, as regards ill treatment, a minimum level of severity is required, which will entail an assessment of all the circumstances in each individual case. Second, the court proclaimed for the first time the Convention prohibits in absolute terms torture and inhuman or degrading treatment or punishment, irrespective of the victim's conduct. The court held that even when applied in combination, the so-called 5 techniques did not amount to torture, reasoning that they did not inflict suffering of the particular intensity and cruelty implied by the word torture. There was a finding before the court that the victims had suffered, and I quote, at least intense physical and mental suffering and acute psychiatric disturbances, feelings of fear, anguish and inferiority, capable of humiliating and debasing them, and possibly breaking their physical or moral resistance. Was there any medical evidence of the alleged torture? From a reading of the court's judgment, you would justifiably be forgiven for thinking not. But if you dig really deep, you will find some fleeting references to some brief medical reports, and in one case there were photographs. You may recall, some of you, what medical reports consisted of for detainees in the 1970s. Little A5 pages with general practitioners' scribbles on them, often running to 4 or 5 lines at most, perhaps 50 or 60 words. Those were medical reports. There was no Istanbul Protocol. By today's standards, this, of course, would be considered primitive. But that was all there was. It was brief, in-depth, detail, analysis, and expert opinion. Notwithstanding these shortcomings, it played a crucial role, particularly in those cases where physical injury was alleged, but of course also in those cases where psychological or psychiatric symptoms were being put forward by the victim. In a later landmark pronouncement of the European Court of Human Rights in the case of Selmouni versus France, the court emphasised the increasingly high standard being required in the area of the protection of human rights and fundamental liberties, correspondingly, inevitably requires greater firmness in assessing breaches of the fundamental values of democratic societies. In other words, we live in a supposedly increasingly wiser world, and we are reminded, of course, that the Human Rights Convention is a living instrument. Since the Labour government brought rights home 15 years ago, torture has featured at the highest judicial levels in the United Kingdom. There is some academic debate as to whether torture was previously outlawed by the common law. Such legal protection as clearly existed belonged to a different branch of the law, namely the criminal law, whereunder behaviour such as assault or murder has always been an offence. On the 8th of December 1988, the UK government ratified the UN Convention Against Torture, and in anticipation Parliament enacted Section 134 of the Criminal Justice Act 1988, which defines torture as the behaviour of a public official or person acting in an official capacity who intentionally inflicts severe pain or suffering on another person in the performance or purported performance of his official duties, the equivalent of the common law tort of misfeasance in public office at its most extreme. The House of Lords took the opportunity to make a comment on the finding of the European Court in the case of Ireland versus the UK, when in the first of the Belmarsh cases, Lords Bingham and Hoffman observed that conduct which the court ultimately found not to constitute a torture might not be thus viewed nowadays. With this exception, their lordships adopted the general approach of the Strasbourg Court to Article 3, thresholds, burdens, the tests, and so forth. Most strikingly, perhaps, in the Belmarsh case, rather different questions concerning burden and standard of proof in torture cases were decided by the House of Lords. The basic issue was the admissibility of evidence obtained by torture as alleged proof that the person was a terrorist. This issue was considered by their lordships in circumstances where, although the UN Convention Against Torture contains a provision requiring states parties to ensure that statements established to have been made as a result of torture are not invoked in any proceedings, this provision had not been incorporated in UK domestic law. Their lordships were split 4-3. The minority speeches are characterised by their colourful language. Lord Hoffman, for example, based his dissent on the need to preserve the integrity of the judicial process and the honour of English law, with the result that, in his words, the stain attaching to such evidence will defile an English court, whatever the nationality of the torturer. Yet another burden and standard of proof failed to be considered in a context where an individual claims that to remove him to a foreign state would expose him to a risk of torture contrary to Article 3, a recurring theme in United Kingdom litigation. In the case of Vilvarlaja v. the United Kingdom, the European Court, in finding no breach of Article 3, adopted the test of whether, in the light of all the material available to the court, substantial grounds had been shown for believing the existence of a real risk of treatment contrary to Article 3. Many of you will recall the context, the Sri Lankan Tamils, and also one of the lessons learned from Vilvarlaja, namely that in international law there are different tests for deciding whether a state may lawfully expel a person to another. There's the Article 3 test and also the Refugee Convention test. I turn to reflect very briefly on the topic of proof of torture in the modern era, to which some reference has already been made. In the case of AM, the central question was whether the reports of a doctor from the Helen Bamber Foundation contained independent evidence that the claimant had been tortured. This particular case is, in my view, illuminating, as it is illustrative of the kind of scrupulous forensic dismantling and dissection of medical reports which has become so commonplace during the past 2 decades. I contrast this case with that of Ireland v. the UK, with which I began. This claimant alleged that she had been detained, raped and tortured in Angola with resulting scars. The author of the reports was a person who had significant expertise, albeit more in the nursing and psychological fields rather than in medicine per se. Notwithstanding, when the Court of Appeal decided the case, her capabilities were specifically complimented. The credentials and qualifications of the author featured in the court's overall conclusion, which was that, unlike the trial judge, it decided the reports constituted independent evidence of torture. Here, as you were reminded, the Istanbul featured in the reasoning of the court. The protocol, the court noting, having been observed by the author of the reports in question. Next, in SA Somalia, the Court of Appeal had to decide whether the approach of the Asylum and Immigration Tribunal to certain medical evidence adduced for the purpose of corroborating the claimant's account of alleged persecution in his country of origin was correct. The court reviewed its earlier decision in Mbanga. It's worth recalling what the error of law was in that case. Namely, the adjudicator had incorrectly and artificially separated the medical evidence from the remainder of the evidence, reached adverse credibility findings without considering the medical evidence, and then went on to examine it. In the SA appeal, the Court of Appeal rejected an invitation to infer that the doctor regarded the claimant's history as consistent with the signs of injury on examination. Why was that invitation made? Because the doctor, astonishingly in retrospect in my view, had expressed no opinion on this, the core issue. I compliment a member of the audience who had the courage to make that submission to the court. Of course, it was unreservedly rejected. The court was unambiguously critical of the doctor. Such a report, it said, is inadequate for the task it is tendered to perform, namely, to corroborate and or lend weight to the account of the asylum seeker by a clear statement as to the consistency of old scars found with the history given. In this context, the expert question of consistency should not be left to the adjudicator as a matter of inference or construction. Once again, the Istanbul Protocol had an erring in the court's judgment. It emphasised every medical report should contain a clear statement of the doctor's opinion as to consistency, directed to the particular injuries said to have occurred as a result of the torture or other ill treatment relied on as evidence of the persecution. The court also emphasised the importance of viewing tribunal decisions in the round rather than cherry-picking and piecemeal. No error of law was found in SA Somalia. I conclude with the following observation from the bench. Where it is evident that there are relevant, extant and available medical records of whatever kind relating to the claimant, the failure of the medical expert to take steps to secure and scrutinise these and to deal with them in the report will, as a general rule, devalue the report and weaken the claimant's case. Medical evidence in any sphere of litigation raises many issues which are nothing if not intensely pragmatic, beginning with old records, contemporaneous records, intermediate records, anything which could have a bearing on the function which the medical examiner or expert is performing in compiling the report. And finally, there is a divergence on certain issues in the United Kingdom and in Strasbourg, and I focus very briefly indeed on the following. Under the jurisprudence of the European Court of Human Rights, evidence of material or information acquired as a result of torture can never be admitted in judicial proceedings. In contrast, as the Belmarsh case decided, the Supreme Court has declined to frame this as an absolute rule. And secondly, whereas the European Court places the burden on the state to prove that torture has not been or will not be perpetrated, the Supreme Court has devised a principle whereby the person alleging that evidence is or will be tainted by torture bears the burden of proving this. These two leading courts are, however, agreed that under international law there is immunity to state officials in civil proceedings relating to torture. Thus, the fundamental right of access to justice of the victim has yielded to the imperative of respect for the sovereignty of nations, which did not land in the UK from some distant planet, but is rather a common law principle itself, namely the principle of sovereign immunity. Thank you very much for your attention.
But I understand you're asking whether, to what extent the approach, say, towards medical evidence in the UK and or other countries could create a sort of a immunity for regimes, state regimes or states that use torture. The reason I don't fully grasp the question is that we actually don't recognise any immune. There is no such thing. Firstly, we're dealing with individual criminal responsibility against direct perpetrators. It's not a question of state responsibility in our court. So we're always looking at individuals, and there are no immunities in our courts. No impunity, not the immunity. But again, I mean, I'm not sure if I even understand, because what would happen when we select a case, we do a preliminary examination. Obviously, if we open an investigation, one of the key questions we look at is whether the case has been prosecuted, the cases or whatever, is this case admissible before the ICC, which looks at whether or not there has been a truly, whether these crimes have been prosecuted before in the state concerned. And we don't just sort of willy-nilly say, okay, great, it's been done. I mean, the court actually looks quite closely at what has been done in a real sense. So I don't see, unless I'm not understanding your question properly, necessarily the connection that how could we because it's almost like starting afresh.
You've answered very well by actually denying the possibility of that connection, and that in itself is helpful.
Yeah.
Though, of course, there is the problem of getting the person before the jurisdiction of the court in the first place. There may be no impunity at the indictment level, but there can certainly be impunity at the jurisdictional level in terms of, and indeed possibly immunity too, in terms of bringing indicted people before the court. But an interesting question. Stephanie, I think there was also a segue into to you there, and there were two questions for you.
So I was asked whether or not there's any legal basis for asserting a presumption that has to be displaced by the Secretary of State if the individual has a medical report that confirms that the injuries are consistent or highly consistent or diagnostic of their account. And what I would say about that is that that argument was advanced in the KV case before the upper tribunal and rejected, and it was advanced on the basis that the decisions of the Strasbourg court in RC Sweden indicate a legal basis for that proposition. So there was some medical evidence, limited medical evidence, which was rejected by the Swedish authorities, but without any contrary evidence of their own. And the European Court in Strasbourg said that was a wrong approach. It was necessary to investigate in light of that material having been produced and to provide their own material. The principle behind that was that, as I've indicated in my report, there's a shared burden of investigation in claims relating to asylum. That's made clear from the UNHCR handbook, and as a general principle has been adopted in our courts, in the Court of Appeal. But the upper tribunal rejected that proposition. It also referred to a case called Singh in Belgium, which in a different context to do with forgery and whether or not documents had been were from the UNHCR. Again, the Strasbourg court said it was wrong in principle for the Belgian state to say we don't accept the veracity of these documents when it could have investigated one way or the other to establish whether they were genuinely from the UNHCR, saying the individual had been recognised as a refugee elsewhere. So the Strasbourg case law seems to indicate that there is this responsibility and this burden. And so obviously it will perhaps be an issue in KV that will be taken up, and there'll be some further ruling on that. But ultimately, what I would say is you don't particularly need to resort to those kinds of principles. It's an ordinary approach to evidence, which in the case that I'd set out in paragraph 31 of my paper, another upper tribunal decision, where the fact that the Secretary of State was unable to cross-examine the individual on the basis of an assertion that they had inflicted the injuries themselves, even though that was the ultimate submission, because they had no evidential basis for asserting that. And so one has to go back to first principles. You can only put a case that you have evidence of. And if you don't have evidence of it, it's impermissible to cross-examine on that basis, and therefore it should be impermissible at the end of the case to say, well, reject the positive evidence because we assert that it's without any evidence that it's not correct. So basic principles of evidence should mean that that's not possible. And it is one of the difficulties that we have to confront, that it has been the approach to the Istanbul Protocol, because within it suggests that doctors do address alternative explanations. The court has, in my respectful position, adopted the approach that it's within your own evidence that you have to positively exclude alternative explanations. And if the doctor is not able to do that satisfactorily for whatever reason, then that is then somehow translated into positive evidence that the person did self-inflict these injuries upon them. So ultimately, I think we have to go back to basic principles of evidence. And if the Secretary of State cannot assert on the basis of any evidence some alternative explanation, whether it's self-infliction or whether it's sports injury or injury on the battlefield, then they shouldn't be able, that matter should not be before the court, and they shouldn't have to adjudicate on it. And especially shouldn't have to adjudicate on it where the question is there a real possibility that this individual was tortured as claimed. Because even if there is a potential possible other explanation, so what? That would not mean that you haven't discharged the very low burden upon you. And I think that we do ultimately just have to get back to basics of what is an evidential case.
Thank you. Please.
Comment on the first two questions. High quality medical evidence is what the judiciary is always looking for, and the better the quality of the medical reports, the more one particular risk is minimised. In the real world, there will always be a judicial temptation, subconscious, to assume a degree of expertise which the judge does not possess. That risk will be minimised the better the quality of the report. As regards Nathan's observation, Nathan, you'll be very pleased to learn that I have instituted a punishing regime of continuing judicial learning and education in the upper tribunal. It's known as CJD. The upper tribunal judge's homework for this weekend will be to study this paper and provide a commentary next week. You'll be very pleased to hear that you will receive exactly the same paper. I need to edit it, but I can assure you that you'll be reading the same paper as all the upper tribunal judges, and in response to your very interesting and practical suggestion, the first tier judiciary will also receive it.